Hi everyone, I am Samidha Hegde. I am interning with LEXIS and Company. I am a third year law student studying in Ramaya College of Law, Bangalore. Today I am going to be explaining you about lease under Transfer of Property Act 1882. Now, lease. Now everyone cannot buy property, everyone cannot become owner because of limited financial conditions, and so but everyone wants to enjoy property rights. Now this can be done through several ways like mortgage, sale, uh, gift, or even lease. Now lease is similar to rent, but it is not exactly rent. Lease is a type of contract, so both the parties to this lease agreement must be competent to contract. Lease is defined under section 105 of the Transfer of Property Act. Now, to explain in a simple way, what happens in lease is that there are two people, that is the landlord and the tenant, and this landlord will give some immovable property for a specific period of time, as lease, which is like rent, and that other person who is the tenant will have to pay some consideration like premium or rent, or it could also be rendering of some sort of service. Now, so I guess you understood what is lease. Now I'll quickly go over the essential elements of lease, which are pretty much what we have discussed in the definition itself. So there are four essential elements to lease, that there must be two parties, the transferor and transferee. Now the transferor is called the lessor and the transferee is called the lessee, and this agreement that they are entering into is called a lease deed or a lease agreement. There must be a transfer of interest in immovable property. Now remember that this is only a limited transfer of interest, not absolute transfer of interest, because absolute transfer of interest means ownership. Now here we are not transferring the ownership, only the right to use and enjoy the property, that is right to possession, is transferred to the lessee, and it is for a specific duration, let's say 2 years, 3 years, or 5 years, or whatever it will be mentioned in the lease deed. And there must be some consideration. It can be in the form of premium, rent, and also service provided to the landlord, that is lessor. Now, so when does this lease agreement come to an end? There are 5 main situations upon which the lease agreement will come to an end, that is terminate. It is also known as determination of lease agreement. It is mentioned under section 111 of Transfer of Property Act 1882. So what are these 5 conditions? That is, by lapse of time, like I told you, that lease deed is for a specific duration of time, a specific stipulated time, and let's say 5 years, and when that 5 years will end, the lease agreement will automatically terminate, and there is no need to even give any notice. So the second situation is by happening of a specific event. This specific event could be like, let's say I have given a lease of a house to some person, and that person is old, and the condition of the lease is that they can that lease agreement will continue until the death of that person. Now that person, if that person dies, then the specific event that is mentioned in the lease deed has been completed. That is, it has happened, and even by that the lease deed will come to an end. It can be anything else, like if I have given lease for the period of war, and if the war will come to an end and peace is declared, then the lease agreement will come to an end. Or it could be because of merger. Now what is merger? So merger is, like I told you, the tenant or the lessee has a limited interest. But if he acquires absolute interest in the property, that is, if the landlord decides to sell the property or gift the property to the tenant, or any such situation because of which the tenant becomes the owner of the property, in that case the lease agreement will come to an end, because one person cannot be both the owner as well as the tenant. Or it can or another situation where the lease agreement can come to an end is by surrender. Surrender can be both express or implied, like if the tenant or the lessee vacates the premises and explicitly mentions that he no longer wants the lease. In that case, that is an expressly surrendering. Or implied surrender could be if the landlord offers a new lease agreement while the previous one is in continuation. That is, the previous lease agreement has not expired and the tenant or the lessee comes to contract in this new lease agreement, or that he accepts this new lease agreement, then the old one will automatically terminate and by implied surrender it will come to an end. Or the fifth condition is by forfeiture. Now forfeiture is like when the lessee's rights are lost. That is, if he breaches the conditions of the lease, like he is not able to pay rent, or he declares himself to be the owner of the property even though he is not, he is only a tenant, and or if he goes bankrupt or he becomes insolvent and he is not able to pay the rent or premium on the lease, on the property that is the subject matter of the lease. In all these cases, by forfeiture, the lease deed will come to an end. So that's it for today. So I hope you liked the video, and I have made some more videos previously. Do check it out. Please share and like and subscribe to the channel and press the notification button for more updates.